Greetings aspirants. Welcome to Narayana IAS. This is Ananta Krishna. Welcome to this new edition of Daily News Analysis. Before getting into the topics that we have chosen for today's analysis, again I have one request for you. As we are producing the videos which are completely in tune with the examination requirements, which are on the dot for the examination requirements, please make sure that you have remained subscribed to this channel such that you receive all the videos as notifications and you can be in tune with the examination pattern and requirements thoroughly. Make sure that you are hitting the bell icon below and remain subscribed to the channel. The one-stop destination for all your civil service examination requirements, that is Narayana IAS. Let's now move to the articles that we have chosen for today's analysis. The first article that we have chosen for today's analysis is from the Hindu, which is titled Supreme Court Ends Immunity for Legislators Who Are Taking Bribes, published on page number 1. The second article again is from the Hindu, which is titled A Vaccine That Prevents 6 Cancers, published on page number 7. The third article that we have chosen is on this India's status of nuclear power program, wherein they are specifically focusing upon the second stage of this particular nuclear power program. The fourth article is again from the Hindu, where it is titled A Case to Reform Bail Law and Guidelines but Make the Right Diagnosis First, focusing on certain substantial issues concerning the bail related aspects. And the fifth and final article is again from the Hindu, where RBI is asking NBBL to ensure that this net banking is interoperable in 2024. And finally, we will have few prelims and mains practice questions, and then we will end the today's daily news analysis. Let's move to the first article that we have chosen for today's. Dear students, embark on your UPSC journey with Narayana IAS Academy. Our esteemed 5-year and 3-year integrated programs are now open for admissions in Hyderabad, Vijayawada and Nellore. Our courses include robust R&D backed initiatives such as daily news analysis, daily news review, which are comprehensive review program for a broader understanding of our day-to-day happenings, which are current affairs. Similarly, we have NCERT program, which is a foundational course that covers all the NCERT syllabi, which is crucial for UPSC preparation. We also have a mentorship program for personalized guidance, and we also have a regular test series for systematic learning and assessment of the student. So begin your journey to become a leader with Narayana IAS Academy today. Embark on this journey, make your dream come into a reality with Narayana IAS Academy. The article is titled Supreme Court Ends Immunity for Legislators Who Are Taking Bribes. As you clearly see that the 7-judge constitutional bench has come up with this particular judgment. This particular article is important for both preliminary and main examination, and particularly the main examination, in which there can be a question on the issues concerning immunities to the legislative members or even the powers and privileges that they enjoy under this Article 105 or Article 194. Moving to the previous year question, look at this particular question. The powers, privileges and immunities of Parliament and its members as envisaged in Article 105 of the Constitution leave room for a larger number of uncodified and unenumerated privileges to continue. As you clearly see, this is the major issue that we have as a progressive democracy. Assess the reasons for the absence of legal codification of the parliamentary privileges. Now, how can this problem be addressed? Asked in 2014, it can clearly show you that this particular topic is thoroughly in tune with the main and preliminary examination requirements. Look at the context. As we have already seen that the Supreme Court has come up with a judgment in which it has held that the members of Parliament and the members of legislative assemblies clearly are not immune to the criminal charges if either they are giving or accepting the bribes, not only to speak on the floor of the House, but also to participate in voting, or also even from abstaining from the voting in a certain way within the legislative house. This has been pronounced in this case of Sita Soren versus Union of India, where the Supreme Court has overturned her own judgment in PV Narasimha Rao versus State, that is CBI or SPE, in 1998 case. In this particular case, as you clearly see, whatever the powers, privileges and immunities that the members of parliament or even the legislative members of the legislative assembly were enjoying under these provisions of either Article 105 or Article 194 are now being subjected to certain qualifications. They are not absolute. We will look into its details. Clearly, under Article 105, it says that no member of parliament, I repeat, no member of parliament can be subjected to any proceedings in the court of law for whatever they have said or for whatever the voting that they have participated in the floor of the house. This is clearly in tune with the separation of powers principle, whereby the parliamentary functioning will be kept independent of any unscrupulous intervention by other two organs of the government. Secondly, the similar provisions are there in Article 194, where they are applicable to members of the Legislative Assembly. As you clearly see that they are granting privileges and also they are granting immunities, whereby this is not only available to the entire house as a collective entity, but it is also available to all the members individually too. This has actually led to number of situations wherein there are certain controversies which were emerging out of this. We will look into the particular judgment which is of the concern in this particular case. In this particular case, what happened is the PV Narasimha Rao government, which was subjected to a no confidence motion, has allegedly bribed few members from few political parties, and some of these members of these political parties were voting in favor of the government which was led by then Prime Minister PV Narasimha Rao. And in this particular case, there was one member named Ajit Singh who did not participate in voting, in spite of the fact that allegedly he has also been charged with this allegation of taking bribes from the other political party which was in power. Now, in this particular situation, the Supreme Court was looking into this issue, and it has stated in this 1998 judgment that the Supreme Court cannot intervene into this issue of what is referred to as bribes taken by the legislators for the cause of voting on the floor of the house, because as you clearly see, the members of the parliament and state legislatures were immune from prosecution in bribery cases as a stand that it has taken. Second, it's following this principle of what is referred to as parliamentary immunity from judicial proceedings for whatever that has been said on the floor of the house or whatever the voting that has occurred on the floor of the house where the members have participated. Second, what happened is in 2012, this member referred to as Sita Soren was subjected to similar allegation of taking bribes, and in this particular case, as she was claiming her immunity under Article 194, she approached the respective High Court in Jharkhand. The High Court has dismissed her plea, and then she has approached Supreme Court in the form of a plea. In this particular plea, she was referring to this judgment given in 1998 in this case of PV Narasimha Rao versus CBI or state. In this particular case, as we clearly know that the parliament members have been granted immunities against any such charges and hence any such criminal proceedings. Now, as this has been delivered by a 5-judge bench in 1998, now the Supreme Court has transferred this case to a 7-judge bench in order to look into this matter again. That is what you see on this particular slide. This verdict was doubted in this appeal by Sita Soren, and in this particular judgment, the Supreme Court had to say few very important pronouncements. One, there is no immunity under Article 105 and Article 194 of the Constitution for receiving a bribe in contemplation of a vote or speech in the legislature. This you have to keep in mind. Second, the bribery for casting a vote or making a speech has wide ramifications, particularly on public interest, then on probity in public life, and then on parliamentary democracy. Clearly, as you see in this, the transparency and accountability as key factors in the functionality of parliamentary democracy have to be upkept as fundamental principles. Second, it is in association with and in line with these two principles that Supreme Court has said that there cannot be any immunity whenever these two are getting violated. Third, unlike the House of Commons where there is a particular history, for example, in 1645, the king has sent some soldiers to the house in order to arrest 5 members of the House of Commons. They have done this because they have a belief that, or the king had a belief that it is the divine right of the king to remain a ruler forever, and his powers and privileges and immunities superimpose or overpower the powers, immunities and rights that are enjoyed by the House of Commons. As the Supreme Court has said, the Indian democracy doesn't have any such ancient and undoubted privileges as you see in the House of Commons, where even today if king or queen had to enter their house, there need to be a permission from the House of Speaker. Third, the judgment also said that, as you clearly see, the privileges in the pre-independence India were there. However, they were governed by the statute that was passed by a reluctant colonial government. They were not there as an in situ factor in the enjoyment of those privileges and immunities. So, this statutory privilege, which is what got transitioned into a constitutional privilege after the commencement of the Constitution. So, clearly drawing a comparison with the British Constitution and also the statutory provisions prior to Indian independence, the Supreme Court said that there is no hitherto convention or practice with regard to these rights, privileges and immunities as it has been incorporated in Article 105 and Article 194. Moving ahead, it said this immunity and these privileges that the parliament and parliament members enjoy is not absolutely immune from judicial review. That is what you see in this particular point. The question of whether a claim to privilege in a particular case conforms to the Constitution and this is amenable to judicial review in the cases such as the current case that it was dealing with. Moving ahead, it also said that the offence of bribery as per the Prevention of Corruption Act is complete just the moment when the illegal gratification is taken by the member of the house, either it is member of parliament or the legislative assembly. So, as you see in this particular point, the Supreme Court was facing two fundamental questions. One is the immunity under Article 105 is absolute, and number two, under the Prevention of Corruption Act, for the purposes of defining whether a particular member of the house has been subjected to the charges of corruption, then can we equate him with what is referred to as public servant? As we clearly know, this Prevention of Corruption Act is applicable to all the public servants. It is these two questions that the Supreme Court was addressing. The first question was addressed in unequivocal terms that it leads to the criminal offence and hence that can be subjected to criminal proceedings. And the second one also says that for the purposes of Prevention of Corruption Act, if the bribery has been done, has been taken, and if this is considered as offence, then this illegal gratification under the Prevention of Corruption Act must be subjected to the criminal proceedings. It is immaterial whether the legislature votes or gives a speech later in the house in terms of the bribe. Provisions of Article 105 and Article 194 have been interpreted in such a way that this particular action which was subjected to immunity was clearly taken away. Moreover, as you clearly see in the judgment of 1998, there is a paradox. For example, the members who have taken the bribe and they have participated in voting, subjected to this judgment, they have been freed from any criminal proceedings. On the other hand, Ajit Singh was charged with this taking this money. However, he did not participate in voting and hence he was subjected to what is referred to as criminal proceedings because he did not participate in voting. Meaning, if you have participated in voting, even though you are charged with a criminal offence, you will be subjected to immunity, and if you have not participated in voting, then you will be subjected to the criminal proceedings that had to be proceeded with. And this has created, as I said, a paradoxical situation, and this paradox has been addressed by this particular judgment. Moreover, corruption wherever it is there, this corruption kills democracy in three ways. One, it creates a government or the system which is non-responsible. The political system is non-responsible system. Second, the political system becomes non-responsive to the public interest. And third, it also takes away this spirit of being a representative democracy. It is in this particular situation, the Supreme Court said its jurisdiction as a competent court to prosecute a criminal offence still exists. Number one. And number two, if you are equating this with the authority of the House to act for a breach of discipline in the form of the contempt proceedings in relation to the acceptance of a bribe, both of these have to be seen separately. The first one will be there even though the second aspect is not proceeded with by the Speaker of the House. Second, it also said the potential misuse against individual members of the legislature, which is the danger that most of the opposition members were actually raising. This cannot be enhanced, this is not diminished by recognizing the jurisdiction of the court to prosecute a member of the legislature who is alleged to have indulged in the act of bribery, by which it means that if one is indulging in act of bribery, then alone he will be subjected to these proceedings. But using these proceedings, the opposition members or the members who have less voice in the House, allegedly less voice in the House, will not be subjected to any kind of political vendetta using these particular interpretations. This is what Supreme Court had to pronounce in this particular judgment. Moving to the next article, we'll do this: a vaccine that prevents 6 cancers. Any disease is important for your preliminary examination, and particularly cancer, which is posing a threat to the public health situation in India, is going to be more important, and that too when we are addressing it through certain solution. This particular article is important for prelims from the perspective of diseases and their cure, and also for mains there are certain technologies and there are certain measures which are involved in improving the health situation in India, and this is hence important from GS paper 2 point of view. Look at the previous year question. Consider the following statements. 1. In tropical regions, Zika virus disease is transmitted by the same mosquito that transmits dengue. Second, sexual transmission of Zika virus disease is possible. Which of the statements given above is correct? Asked in 2017, any kind of viral disease that you see which had its relevance on the public health as a burden can be a question for the exam. What is the context? Remember, the January month has been observed as Cervical Cancer Awareness Month. This you have to keep in mind. Second, every year March 4th is being observed as International Human Papilloma Virus Awareness Day. It is in this particular context this article has been written, and they have discussed about this new solution that has been offered in the form of a vaccine that could address 6 various forms of cancer that we know in India. There is another cancer which could even address 9 varieties of cancer, but that is still in vogue in USA alone. What is this cervical cancer? Remember, this is linked to what is referred to as human papilloma virus, and remember, this is a common virus which has transmitted through particularly sexual contact. Second, there are 2 ways in which we can prevent this. One is referred to as effective primary approach, which is what this HPV vaccination is, and number 2, secondary preventive approach, which is where you go for screening and also treat whatever the precancerous lesions which are identified. This will prevent most of the cervical cancer cases. Third point, most important point, there are at least 14 human papilloma virus types which have been identified as oncogenic, that is potential to cause cancer in a human being. And out of these, what you find is these HPV 16 and 18 types are considered to be the most oncogenic and most virulent. They have been found to be responsible for at least 70% of all cervical cancer cases globally. Moving ahead, what is the vulnerability situation in India? Remember, this is the fourth most common cancer among women worldwide, and cervical cancer claims the lives of more than 3 lakh women every year. That means at least one life for every 2 minutes. This is the level of vulnerability that we have. Second, 9 out of 10 women dying of cervical cancer clearly live in the lower and middle income countries. This is where this virus now offers a lifeline for those who have been infected with such cancer. Third, the cervical cancer is the second most common cancer in India after breast cancer. And fourth, given our population size, nearly 500 million women above the age of 15 are at the risk of this cervical cancer, and hence the significance of this vaccine for our population, not just our population, even for those lower and middle income countries. What this particular vaccine is, this HPV vaccine and screening for precancerous lesions, as we have seen earlier, are key strategies for preventing cervical cancer. Here, the WHO has outlined what is referred to as 90-70-90 intervention target 2030, and this is aiming at vaccination, screening and treatment for women. Here, the Indian government has come up with this HPV vaccine introduction. This was even though introduced in 2008 in India. Now, the significance of this vaccine is that this has been included in Universal Immunization Program in 2023. Now, what this Universal Immunization Program is? As we clearly know that this provides vaccines against 9 particular diseases nationally and 3 particular diseases subnationally. What are those diseases which are protected or provided this immunization nationally? 1. Diphtheria, pertussis, tetanus, polio, measles, rubella. All these are important from your preliminary examination. They might ask you, what are those diseases which are not included as part of national immunization program? So, this includes even hepatitis B, meningitis and pneumonia, which is caused by, as you see here, Haemophilus influenza type B. There are few which are subnationally implemented, which is rotavirus diarrhea, pneumococcal pneumonia and Japanese encephalitis. Now, as you clearly see that because of this inclusion into the Universal Immunization Program, as it is targeting close to 2.7 crore newborns and 2.9 crore pregnant women every year, this is going to serve as a major step in addressing these public health challenges of cancer and particularly cervical cancer. Now, we shall look at what this WHO's 90-70-90 strategy is. Clearly, 90% of the girls must be fully vaccinated with the HPV vaccine by the age of 15 years alone. Second, 70% of women must be screened using a high performance screening test by the age of 35 and again by the age of 45. Third, 90% of the women who are detected with cervical precancer and cancer lesions must receive treatment and care. It is this 90-70-90 strategy which has to be implemented. Now, what are those challenges in India during implementation of either Universal Immunization Program or even this 90-70-90 strategy? 1. Clearly, there is limited accessibility. Number 2, whatever the physician perception that is there, that becomes ultimate in diagnosing everything. Third, there are certain safety and effectiveness concerns with regard to these vaccines which have been now brought into implementation. Moreover, there is hesitancy in terms of vaccine recommendation. There are also certain such hesitancies even back in the rural areas. Moreover, there are also transmission related misconceptions that are there in rural areas because of taking the vaccines. And finally, there are certain parental engagement challenges which also cause this particular challenge in addressing the cancer through the papilloma virus related vaccine. Moving to the next article, we will discuss this Science and Technology article titled The Status of India's Nuclear Program. There is one significant development where the Prime Minister was participating in what is referred to as core loading at this Madras Atomic Power Station in Kalpakkam. This has raked up significant debate in India over the future of nuclear power in India. We will look into the details. This particular article is significant from this nuclear power program where we have certain stages involved, and this particular atomic power plant is related to one particular stage, that is stage 2. Then for mains examination, this is important from this indigenization of technology and developing new technology as an aspect from UPSC syllabus perspective. Look at these previous year questions. Take this prelims question asked in 2011. Straight away it says the function of heavy water in a nuclear reactor is to slow down the speed of neutrons, increase the speed of neutrons, stop the nuclear reaction, none of the above. As you clearly see, the answer is A, and this is again, as I repeat, tells you why this article is important for both preliminary and main examinations. Look at this mains question asked in 2018 for 250 words. With growing energy needs, should India keep on expanding its nuclear energy program, and discuss the facts and fears associated with nuclear energy post Fukushima disaster and post this situation of what is referred to as deglobalization as a process and worldwide fears around the nuclear power and also nuclear weaponization. This had been one issue which has been asked in the exam. Moving ahead, what is the context? As I was already referring to, this core loading at India's first indigenous fast breeder reactor at Madras Atomic Power Station at Kalpakkam has commenced. All these points have to be remembered. This fast breeder reactor as such connotes one particular technological expertise. We will refer to it a bit later. Second, this is a 500 megawatt electricity producing unit. Third, as I said, you have to remember this Madras Atomic Power Station at Kalpakkam, where this is located. In order to implement this, the government has created a special purpose vehicle in 2003. This is referred to as Bharatiya Navikiya Vidyut Nigam Limited, shortly referred to as Bhavini, in order to operate this most advanced nuclear reactor referred to as prototype fast breeder reactor. In short, we refer to this as PFBR. This has been designed and constructed indigenously by Bhavini with contributions from 200 Indian industries, by which it means that even though we say that this is thoroughly government owned subject in terms of what are those subjects which are open to various industries, whether they are open to public or private industries, this particular program has invited participation of numerous private sector participants. On the other hand, once it is commissioned, it will place India as second country after Russia to have such commercial operating fast breeder reactor. Moreover, this is an advanced third generation reactor and hence it has certain passive safety features. All these are important points with regard to this PFBR from the preliminary examination perspective. Now we shall look at what this nuclear fission as a reaction is. Clearly remember, when there is a radioactive material, this nucleus of an atom of such radioactive material can absorb a neutron and this will get then destabilized and this will break into two while they are releasing some energy. It is this process which we use in order to create the nuclear power. As you clearly see that this is an induced reaction. Apart from such induced reaction, this may also occur naturally through what is referred to as concept of half-life for any radioactive material, where their decay will be naturally occurring, leading to that so-called half-life in a particular time period. Moreover, if this destabilized nucleus is releasing more neutrons, then the reactor's facilities will attempt to use these neutrons which are being released in order to instigate more such bombardments, whereby this will instigate more such fission reactions. Hence, continuity in producing the what is referred to as nuclear power. We look at this so-called nuclear program. In this particular nuclear program, at stage 1, India has operated what is referred to as pressurized heavy water reactors. In these pressurized heavy water reactors, we have this nuclear material or the radioactive material which is referred to as fissile material, wherein it can subject itself to reaction with these neutrons and then split into two and releasing further neutrons. The natural uranium is what we use this, which has a minute proportion of what is referred to as uranium-235, which is what actually undergoes this chain nuclear reaction. Second, in order to have these neutrons which are at higher speeds hitting this uranium-235, in order to release that energy and also in order to release more neutrons in order to carry on the chain reaction, we use what is referred to as moderator, and this moderator has to be less denser than whatever the fissile material that we are using, and hence this less dense moderator will slow down the neutrons in order to carry on this chain reaction in the way that we want, whereby this neutron must hit this minute component of uranium-235 alone. And here, after this chain reaction, what you see is plutonium-239 as byproduct apart from the release of energy. Now, in the second stage, through this so-called prototype fast breeder reactor, we will not use any moderator because we want the neutrons to be fast enough. They are these at their speeds, and this fissile material is again apart from U-238, which has this minute proportion of fissile material called uranium-235. We also use plutonium-239. What is the main advantage of this and why we are so focused on this second stage of India's nuclear power program? Particularly because as we continue the chain reaction through this so-called nuclear fission, what this second stage does is, as plutonium-239 is hit with the neutrons, it releases more plutonium-239, that is more radioactive material, which is what make it very, very significant stage. And hence, as you are getting more radioactive material, you can continue this nuclear power program continuously and endlessly. Third, as you clearly see here, as byproduct, apart from this energy, apart from plutonium-239, you also have what is referred to as uranium-233. And in this particular stage, we also want to use what is referred to as thorium-232, where this is abundant as monazite deposits in India. Nearly 25% of the world's deposits are found in India. We want to even utilize these resources in order to come up with this uranium-233 as the byproduct, hence as a new fissile material for the next stage. This is what stage 3 breeder reactor is. This is also a breeder reactor, as we clearly know now that it is uranium-233 which is used as the fissile material. Because of the presence of or availability of this thorium reserves in India, Homi J. Bhabha, who designed this 3-stage program, had this 3-stage to be designed rather than 2-stage program alone. These 3 stages would make us completely self-sufficient in nuclear energy. Now we shall look at this PFBRs in India, which is the second stage which had been in focus in this particular news. At Kalpakkam, this was built by 1977. However, it has dealt with number of issues such as numerous delays. For example, after that 1975 nuclear blast, wherein the world has imposed lot of sanctions on India, there was sudden stoppage in this particular program. Second, similarly, we also had such issues even after second nuclear test. Moreover, there were also cost overruns. As we have already seen, in 2003, in order to fast pace this implementation of fast breeder reactor program, that is stage 2 of India's nuclear power program, government has formed this special purpose vehicle referred to as Bhavini. In spite of this, we see that there are number of what is referred to as delays in the implementation of this particular program. In 2003, the government had the target of implementing this by 2010. We had certain budgetary allocation, and now this had been expanded in 2008, and 2010 as deadline has become 2015. So this postponement has led to most of the cost overruns. Moreover, there were also concerns with regard to certain promises that they were making. These promises were increasing the nuclear energy footprint in the entire energy footprint that we have in India. Here, the Indira Gandhi Center for Atomic Research, which has designed this PFBR, has come up with certain proposals. In this particular proposal, they said that, as we have seen in the current news, they want to bring up one new nuclear reactor every financial year since from this particular financial year of 2024-2025. Moving ahead, as there were concerns with regard to this PFBR, there were also suggestions to go for what is referred to as small modular reactors. As you clearly see that unlike that 500 watt energy, megawatt energy nuclear power plant, you have here the maximum capacity of 300 megawatts. And moreover, this requires less land, and also this can accommodate more safety features. Second, this can also work with low enriched uranium, and hence India can import such enriched uranium which is of low grade from USA and other such countries under this 123 agreement. And we clearly know that there are various countries with which we have civilian nuclear deal after signing of this 123 agreement. And there is one challenge that we have. Increasing the SMR's contribution would require amendments to the Atomic Energy Act 1962 and other related such statutes in order to allow private sector participation, which we want to do in the current project. And this must be done under the oversight of the Atomic Energy Regulatory Board, which also is both nuclear fuel and waste controlled by Department of Atomic Energy, and this is the regulatory board for both of these according to international safeguards. And hence there is a legislative change which is also required in order to bring this into implementation. Now we will see certain challenges to this so-called stage 2 of the Indian nuclear power program. First particular challenge that was there was with regard to the tariff for solar electricity has come down to the level of 2.5 rupees for every kilowatt hour, as against the nuclear electricity which is costing around 4 rupees per kilowatt hour, increasing the cost of production. However, as we clearly see that globally we are moving towards more and more energy which is of ecologically friendly, and hence in spite of this cost being high, our focus and the global focus again is back on nuclear energy. Second, there is a technical challenge. Clearly, it is hard to handle these particular reactors than other reactor designs because you are allowing the neutrons to be faster, you are using more radioactive materials such as plutonium-239, then you want to have uranium-233 as the fissile material to be used in stage 3, and this U-233 can be 100% utilized. However, storing them, getting them is a very difficult process. Alongside, you also have other byproducts such as thorium fuel cycle, which produces these products such as cesium, actinium, radium and radium-228 apart from thorium-230. All these fissile materials are also brought as the byproducts in this thorium fuel cycle, and all these isotopes are radioactive in their own ways, which in fact are complicated both in terms of handling and also in terms of storage. There is also another challenge which is referred to as executive challenge. Whenever there are resistance and reactions to this nuclear power program by the civil society groups, the Department of Atomic Energy a heavy-handed response to the safety concerns. Alongside, you also have one more very important concern which is referred to as regulatory concern. Clearly, we know that Atomic Energy Regulatory Board is the one which is regulating the nuclear waste and also nuclear fissile material. However, there is a challenge here. The challenge is that it has been set up by the executive order. But we know that in 2015, International Atomic Energy Agency, that is IAEA, has urged India to come up with a standard which is internationally acceptable. For doing this, they must have what is called as a body or regulatory body which is backed by the statutory provisions. This statutory legal provision has been initiated by the Department of Atomic Energy with the introduction of what is referred to as Nuclear Safety Regulatory Authority in tune with those required international standards. However, there was a criticism that there is too much of involvement of the union government in controlling this NSRA's composition and operation. It is these challenges, if addressed, we can have the fast breeder reactors to be commercially operationalized in India, meeting the energy requirements in tune with the ecological challenges that we have to address, such as climate change. Moving to the next article, we'll do this article titled A Case to Reform Bail Law and Guidelines, but make the right diagnosis first. Even though there are various opinions and various considerations over how this so-called bail as a system is functioning, what are those guidelines which have to be in place? The problem with the current opinions and current debates is that they have not done the right diagnosis of the entire issue. This right diagnosis will place where the bail system is, and hence it is possible for us to understand what might be the possible way forward. Moving ahead, this particular article is important from particularly the prison reforms, and also this is important from the various government policies and interventions which are necessary in order to make sure that the right to freedom, right to life and liberty, and right against arbitrary arrest are upkept in accordance with the spirit of the Constitution. What is the context? Chief Justice of India recently has expressed his concern. What about this concern? This concern is about the growing reluctance in the lower courts, particularly amongst the trial judges, to grant bail to those who are accused. Why this is happening? What is that right diagnosis that we have to do? There are certain issues which we have to keep in mind in order to make this right diagnosis possible. First of all, keep in mind that every individual is guaranteed with what is referred to as right to freedom under Article 19 of reasonable restrictions. More important than this, Article 21 is guaranteeing your right to life and personal liberty, by which it means that unless there is liberty for you, your right to life is just meaningless. Given these two, and given the fact that there are protections available against any sort of arbitrary arrest, because this moves and this goes against the right to freedom that is guaranteed and right to life and liberty that is guaranteed under the constitutional scheme, these have to be understood and these have to be prevented. Now, whenever there is this situation of implementation issues in implementing this bail as a norm, remember the principle of presumption of innocence becomes very, very important. Rather than this, trial courts have followed what is referred to as bail. So fundamentally, in order to make sure that this right to freedom and right to life and liberty is protected, there have to be first of all safeguards. What are those safeguards which prevent these possibilities? Remember, the arbitrary arrest and arbitrary detentions in the form of, for example, preventive detentions. Whenever we see, we see that the law and order system and the establishment would make these arrests under certain notions. For example, if a particular individual has to be produced in court, police always demarcate in writing that the arrest is necessary. Unless and until there is arrest, he cannot be produced in the court. Clearly goes against the right against arbitrary arrest, because this is thoroughly arbitrary and notional. Second, remember, even when the person has been arrested, the implementation can be in such a way that immediately he can be granted bail and he can be released in order to again get back his right to life and liberty and right to freedom. However, this can occur only when the bail norms would function under the principle of presumption of innocence, meaning the individual has not committed this offense. We have to make sure that this right trial is concluded. Until this right trial is concluded, he can be released because we are under the presumption that he is innocent. Second, the trial courts must also consider in number of offences what is referred to as bail as the fundamental requirement but not jail. Why are we saying this? Keep in mind, over 75% of India's prison population are under trials, and much of these are there for few years in these jails. And we also see overcrowding as a problem within Indian jails, within Indian prisons, which is at this level of 118%. And most of the times we observe that these under trials would have a social background wherein either they are belonging to the scheduled caste or scheduled tribe communities or even the minorities. Apart from this, there is another social dimension to this, that much of these also are migrants, and most of the times there are persons who do not have any ownership or association with any kind of assets, and there are also individuals who do not have any kind of contact or connections with the families, hence making them socially most vulnerable, and hence we are seeing them in the jails as under trials. It is hence this lack of safeguards with regard to all of these which becomes a fundamental issue in this bail as an issue. This is the right diagnosis that is necessary in order to bring about changes. Moreover, as you clearly see, when you are implementing this bail as an adjudicatory process, whenever you see bail as an adjudicatory process, it is denied straight away, first of all, by the trial courts, because they feel that their presence in the prison would make the trial easy, complete and legal. However, in such cases where the bail was granted, even in these cases you find that procedurally they will be asked to pay as bond amounts ranging from 25,000 to 5 lakhs, depending upon the nature of the crime and also depending upon the subjective discretion of a particular judge. And this is what leads to what is referred to as failure of the bail adjudication system. Moving ahead, you also have this challenge of approach to the bail adjudication. The power to grant bail, as we know, is largely based on the court's discretion. As this is based on court's discretion, as we see, this is becoming more and more arbitrary. However, Supreme Court has time and again stated through their guidelines that whenever there is a need to release the applicants on bail, that has to be done. Second, you have to always validate the denial of bail in writing. You have to mention the reason why they have been put behind the prisons again. Third, as you are mentioning, you must also record why you have rejected the bail. This approach to bail jurisdiction hence also see lot of negative connotations. Lastly, you also have, as we have already seen, the constitutional issues involved. What must be done in this particular regard? Keep in mind, there is necessity of judicial training and specific guidelines which are serving as framework and inviolable rules for the lower courts. Second, you have to make sure that the bail amounts are revised in such a way that whatever the bail amount that you are asking is in tune with the necessity of social justice to everyone. As you clearly see in Article 39A, which has been added by the 42nd Constitutional Amendment Act, it talks about access to social justice for every individual, particularly those who are vulnerable, and then come up with this idea of free legal aid to those who are such vulnerable. This is what you see here in this particular next suggestion, enhancing the legal aid. All said and done, this also boils down to the necessary legislative reforms within this Bharat Nyaya Samhita, which has been brought into force recently, and these legal reforms must hence bring about these necessary changes pertaining to ensuring that there are safeguards, ensuring that there is right approach to adjudication, and ensuring that there is way in which the assumptions are now being adhered to has been transformed into the required assumption that the presumption of innocence is taken into consideration while a particular trial process is conducted. Moving to the next article, we will do this article where RBI is tasking the NPCL Bharat Bill Pay Limited to come up with this idea of interoperability in the net banking to within this same financial year. Probably we may term this as the next important evolutionary step which is happening in the phase of revolution that we are in with regard to the payment system in India. We shall look into the details. This is clearly relevant for UPSC preliminary examination, where the question may be on NPCL, the question may be on interoperability, the question may also be on this NBBL. Moving ahead, look at this previous year question asked in 2017. Consider the following statements. National Payments Corporation of India helps in promoting the financial inclusion in the country. Second statement, NPCL has launched RuPay, a card payment scheme. Clearly, this particular topic is in tune with your preliminary examination requirements. Moving ahead, let me look at the context again. The RBI, as we have seen, has tasked this NPCL, that is NPCL Bharat Bill Pay Limited, with a particular aspect of payment system, that is the interoperability. This had been a challenge in most of the economies, including India. But with regard to what is referred to as this United Payment Interface, that is the app-based payment systems that we have, we could achieve this interoperability because of the adoption of the Japanese idea of what is referred to as the quick response code, that is the QR code, where there are three types of systems which we have evolved with regard to such payment systems. One of those particular QR codes that we have evolved is the UPI QR code and then Bharat QR code. This Bharat QR code has been developed using the services from MasterCard and Visa by NPCL. And we know that this is interoperable because as in practice you might have experienced this, you may have a Paytm as an app and you are going to scan it. Similarly, you may have PhonePe as an app, you are scanning it and then you are delivering or paying your money to a particular app which is not similar to your own app. This QR code has been used to address this interoperability issue when you are making this app-based payments. What about the current issue? Before looking into the current issue, let me also look at some of the very foundational details for NPCL, which is relevant, which is important for your preliminary examination. As you clearly know that this has been coming to being as a regulatory authority after enactment of Payment and Settlement Systems Act, Payment and Settlement Systems Act 2007. Number 1 and number 2, as you clearly see, this was promoted centrally by RBI and there are 10 major banks which are participating: SBI, Punjab National Bank, Canara Bank, Bank of Baroda, etc. Even those few private sector banks including ICICI Bank, HDFC Bank, Citibank and HSBC, in order to promote this particular regulator as a one who is participating in the actions of regulation as a market entity rather than as led by the government. Third, it had these objectives of consolidating and integrating various payment systems and then evolution of robust retail payment system in India. Moving ahead, it has come up with these affordable payment systems in the form of either UPI or in the form of even the Bharat Pay, wherein it is serving the requirements of common people. Moving ahead, what is this interoperability is all about? Commercially, you might be having your account in one bank. Technically, your bank might be using a particular technology which is distinct from another particular bank. Now, in order to have a payment to be done to a particular merchant who is having his account in another particular bank, for example, A is the bank in which you have the account, B is the bank in which the merchant has the account. Now, you are trying to make these payments using your internet banking. In this particular case, if B is having his account in some other bank, then the bank A must have their agreement with bank B such that his payment would be easily transferred to bank B for the purposes of this particular transaction, by which it means that bank A must have their agreement with bank C, bank D, bank E, irrespective of how many banks are there. With every bank, this particular bank A, for the purposes of you as a customer, must have agreements with all the other banks, because the merchant might have his account in any of these banks. This makes it difficult for the bank to have so many agreements, number one. And number two, this will also add an extra cost for the functionality of this particular bank. It is this which had to be and which will be resolved when we come up with this idea of what is referred to as interoperability. So, this internet banking must evolve as a preferred channel for various payments. As you see, with regard to UPI payment system, there is one fundamental problem that we have to make note of. That is, the volume of transactions are very, very high, even though the value of transactions are very, very less. It is this issue which is putting lot of burden on the banks. Even 1 rupee transaction is being done through the UPI payment systems, and hence they want the consumers to move towards a better system, that is internet banking. Second, this is, as I said, is charged with this problem of lack of interoperability, and for this to happen, the payment aggregators are the ones that the banks have to look at and get into agreement with. So, integrating with each payment aggregator, as we have seen in this example, is not possible, and hence there is lack of standardized payment system in this particular aspect, which is what has to be brought into force. Moreover, this will streamline the payment processes in a much more easier way. This will also streamline the payment systems in a much more simplest ways. Having completed the discussion over the articles, we shall now move to the practice questions. Take this first prelims practice question. Consider the following statements. NPCL, that is National Payments Corporation of India, was established in 2008 by RBI in collaboration with the Indian Banks Association, which is the correct statement. We know the second statement is one of the important objectives of NPCL is to promote affordable payment system to serve the common people, which is also a correct statement, and hence answer has to be C for this particular question. Move to second question. Consider the following statements. First statement, small modular reactors, that is SMRs, have a power capacity of up to 300 megawatt energy per unit, which is what is right statement. The second statement is the third stage of the three-stage nuclear power program in India is to make use of the vast thorium deposits in India, which is also a correct statement. Hence, answer has to be 1 and 2 only, that is C. The third question, consider the following statements regarding the immunities provided to the members of the Indian Parliament and state legislatures. The first statement says, Article 105(2) of the Indian Constitution provides immunities to members of Parliament and members of state legislature in respect of anything said or any vote given by them in the Parliament or any committee thereof, which is a false statement because this provides only to the members of Parliament alone. Second statement, Article 105(2) also grants members of Parliament the right to exemption from attendance as witnesses in court while the Parliament is in session, which is also a false statement. Hence, answer has to be neither 1 nor 2. Moving to fourth question. Consider the following statements regarding India's nuclear program. India's first indigenous, fully designed and constructed prototype fast breeder reactor is commercially operationalized. This is a false statement. We know PFBR is developed by Bharatiya Namkiya Vidyut Nigam Limited, which is a correct statement. The third statement, it uses heavy water as a moderator for initiating nuclear fission reactions, which is a false statement, and hence answer has to be 2 only in this particular question. Moving to the fifth question and the final prelims question. Which of the following vaccines is not covered under the universal immunization program in India as of now? That is, A, vaccine for Japanese encephalitis, which is we know is there. Tetanus vaccine is also there. Vaccine for pertussis is there. Even though it has been asked to include in the human papilloma virus vaccine in the immunization program, it is not yet been added. Hence, answer has to be D in this particular question. Moving to the mains practice question. Critically evaluate the need for reforming the bail system to ensure it upholds the principles of justice and equality. Suggest measures to make the bail system more equitable. 15 marker, 250 word limit. How to approach answer for this particular question? You have to introduce by defining the importance of bail system and the importance of this bail system in the criminal justice system, whereby this right against arbitrary arrest is what you are trying to uphold. Second, you are also trying to call for the need for reforms in this particular context of this question, where this problem of under trials and the problem of overcrowding can be mentioned as a current trend in the prison system in India. And you can also mention how the marginal sections are affected disproportionately, and you can also mention how it affects all the fundamental rights which are significant in order to make sure that you have your freedom and liberty. Moreover, you can also mention in the same body the need for reforms wherein measures in guiding the judicial discretion, bail amount, legal aid and also the legislative reforms can be written. You can also mention how these measures will make the bail system more equitable. In conclusion, you can reiterate the potential benefits of such reforms, including a more fair and just legal system that is possible. I hope you have enjoyed this session, and please like, share and comment on the video, and don't forget to subscribe to our channel Narayana IAS, one-stop destination for all of your civil service examination requirements. And one more, please hit the bell icon that you are seeing below such that you receive all those video notifications which are added afresh to our channel, that is Narayana IAS. Thank you one and all.